Good morning, everyone. Good morning to all the members and friends who are all assembled here today virtually to celebrate the 71st Constitution Day of India with Maharashtra National Law University, Mumbai. We have with us today on the panel Dr. G. Mohan Gopal as the chief guest of our program, Honorable Vice Chancellor Professor Dr. Dilip, sir, respected Registrar Professor Anilji Variat, sir, Head of Department Undergraduate Dr. Kiran Rai, and the Assistant Registrar Academics, Mr. Sajid Sheikh. A very warm and hearty welcome to each one of you, and very warm welcome to all the participants. Today we are celebrating the Constitution Day, which is also known as the National Law Day. It is celebrated in India on 26th of November every year to commemorate the adoption of the Constitution of India, which was adopted 71 years ago on 26th November 1949 by the Constituent Assembly. The Constituent Assembly basically met for 166 days for 2 years, 11 months, and 18 days before the Constitution was finally adopted. The Ministry of Social Justice and Environment on 19th November 2015, they notified the decision of the Government of India to celebrate 26th November as the Constitution Day. Celebrated as a mark of tribute to India's first law minister, Dr. B.R. Ambedkar, who played a pivotal role in drafting the Indian Constitution. Now, relating the quote of Dr. B.R. Ambedkar on the Constitution, law, and order with the current dreadful times of pandemic, I would like to read out the quote as quoted by him. It says that law and order are the medicine of the body politic, and when the body politic gets sick, medicine must be administered. So the government of India, Ministry of Law and Justice, they had decided to celebrate the 70th Constitution by a year-long program. The Bar Council of India, they had instructed all the law universities and law colleges to organize months as per the direction of government. The MNLU Mumbai to mark the 70th anniversary of the Constitution. So the details of the program will be shared by Ms. Manisha Katyal, who was also the student coordinator program conducted by MNLU at the end of the session. So when we talk about the Constitution, we talk about the preamble. So the preamble of the Constitution, set apart from unfolding the aims and objects on the Constitution, contains the fundamental values and the philosophy on which the Constitution is based upon. So as the Supreme Court has rightly pointed out in the case of Beguvari, key to open the minds of the makers of the Constitution. Therefore, I request Mr. Sajid Sheikh, the Assistant Registrar Academics, to commence today's program by reading the preamble of Indian Constitution. Over to you, sir.
A very good morning to all of you. Thank you, Gauri, for this opportunity. So I'll just read the preamble of the Constitution of India. We, the people of India, to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you all.
So it is rightly indicated by the preamble that the source of authority of the Constitution lies in the people of India. That is the true spirit of democracy. So on this, Pandit Jawaharlal Nehru had said that freedom, democracy, and peace are not just mere words, but powerful ideas and thoughts that guide us as a nation. So to celebrate the 71st Constitution Day of India, we are very much honored to have Dr. G. Mohan Gopal as our chief guest. So I would request Dr. Kiran Rai, who is the HOD undergraduate at MNLU Mumbai, to introduce our esteemed guest. Over to you, ma'am.
Thank you, Gauri. A very good morning, a warm good morning to the Honorable Chief Guest, Professor Dr. G. Mohan Gopal, Honorable Vice Chancellor, respected Registrar, respected AR academics, and other faculty members, and dear students. On this Constitutional Day, we are delighted to have an eminent guest, Professor Dr. G. Mohan Gopal, who has contributed immensely not only to legal knowledge, but also to judicial reform. Sir is currently coordinator of the Center for Legal Change, which is a web-based platform for discourse on law and justice. Sir is also a member of the National Judicial Academic Council of the Supreme Court, which is chaired by the Honorable Chief Justice of India. Sir has been a director of the National Judicial Academy from 2006 to 11, and then he was a chairperson of National Court Management System Committee from 2012 to 2019. This is a national committee of the Supreme Court of India established by Chief Justice of India to reform and strengthen court management systems of India. Before proceeding for judicial reform and taking care of judicial education, Sir was Vice Chancellor of National Law School of India, University, Bangalore. Sir was also a former member of various national regulatory bodies, including the Law Commission of India, the Securities and Exchange Board of India, the University Grant Commission, the Copyright Law Board of India, and the News Broadcasting Standards Authority. Sir has served as a director of the Rajiv Gandhi Institute for Contemporary Studies. He worked at the World Bank in Washington, D.C. for over 2 decades, where he became chief counsel in the legal department. Sir has also taught at Georgetown University Law School, Washington, D.C. as an adjunct professor for 9 years. And he was also in Faculty of Law, National University of Singapore as a lecturer in law for 3 years. Sir has worked as legal counsel in the Office of General Counsel of the Asian Development Bank, Manila. And before he went on to this illustrious career, Sir has a very high, illustrious academic record as well. He has done his doctoral degree in law from Harvard School, which he completed in 1984. And he has master's degree in law also. I beg your pardon. So he has completed his graduation from the Delhi University, his LLB. Sir regularly contributes his opinion pieces in Frontline, the Indian Express, the National Herald, and opines about the contemporary issues that concerns the citizen of India. I welcome Sir, and I would request the members that if they can call upon the Sir to deliver his address. Over to you, Gauri.
Sir, I would request our guest to enlighten us with his words of wisdom. Sir, your microphone is off.
I think it's fine now. Can you hear me?
Yes, sir.
Were you asking me to speak? The voice broke up, so I could not hear what you said.
I will request you to enlighten us with your words of wisdom.
Thank you so much. I don't know very much about words of wisdom, but I'll certainly share some thoughts with you. Let me begin by sending my warm regards to and respect to the Honorable Vice Chancellor, the Registrar, and all the faculty members and the students. Let me thank you and all those who participated in the last few minutes for your participation, and thank you to Professor Kiran Rai for her kind introduction. Let me thank all of you for giving me this very valuable opportunity to share some thoughts with all of you on on this very historic day. In fact, I would say it is one of the most historic days in the political history of humanity. The day in which almost 1/6 of at that time, the population of the world embarked on a journey which the then Prime Minister of England, of the United Kingdom, said was the greatest experiment in all of history, where a very large and quite impoverished population was adopting the most highly evolved systems of governance in something that was completely unexpected. Ideas like democracy and rule of law were associated only with a handful of countries with high levels of education and high levels of material well-being. But for a country such as ours to move ahead of them and establish a system based on one person, one word, one vote, universal franchise in 1949, when we adopted the Constitution, the Constituent Assembly adopted the Constitution, was unexpected, unpredicted, and unbelievable to the whole world. And that we are today celebrating the 71st anniversary of that historic day is a tribute to the people of this country, to the common people of this country. So it's a great honor to be able to reflect with you on this audacious experiment of the people of this country, and to see where we are and what we should do about it. I greatly appreciate the topic that the university has assigned to me, which I appreciate the content and the context, and that is the role of the Indian Constitution in strengthening democracy and the rule of law. After I thought about it a lot, I came to the same topic in a slightly different way, and perhaps that is a result of reflecting on the history of the Constitution. Perhaps the topic, in my view, in my own understanding, would be the role of democracy and rule of law in strengthening the Constitution. Because the first topic seems to suggest that the Constitution is the ultimate, is what we are seeking to strengthen, and democracy and rule of law are instruments. But actually, it's the other way around. The Constitution is the instrument, and ours is a pilgrimage to democracy and the rule of law. And so we have to understand what is the role of democracy and rule of law in strengthening the Constitution, so that the Constitution will be a bulwark, a very important protection for the people to advance in their journey. And this way of looking at the topic may also suggest that a weakening of democracy and rule of law will actually weaken the Constitution, that the Constitution derives its strength from democracy and the rule of law. And an attack on democracy and the attack on rule of law is actually an attack on the Constitution. And therefore, our focus should be on these interrelated these concepts in an interrelated way, but with the ultimate objective of strengthening democracy. Let me begin by recalling in this context the words of Sarojini Naidu, one of the most eloquent spokespersons and one of the most eloquent leaders of our freedom movement, an extraordinary woman who inspired the leaders of the freedom struggle through her poetry and her eloquence. She said on 11th December 1946 in the Constituent Assembly, the third day of its functioning, it started on the 9th December, so the 11th December was the third day. And she said to the Constitution that she said to the Assembly that the Constitution would be, at the time still being drafted, the immortal charter of India's freedom. The immortal charter of India's freedom. So we suddenly understand now, or we see how it was viewed at the very beginning of the Constituent Assembly as a charter of India's freedom. And then she says a charter that restores to our mother still in fetters, still in chains, her rightful place as torchbearer of liberty, love, and peace. This is one of the first statements in the Constituent Assembly about what the Constitution is, the Charter of India's freedom, that would restore to India, our mother, she calls India, our motherland, our mother still in fetters, still in chains, her rightful place as the torchbearer of liberty, love, and peace. That was the idea, that our country would be the torchbearer of liberty, love, and peace. And that was only to be understood, that was only understandable because we had fought a freedom movement based on the idea of nonviolence, the only and the first example in the whole world of freedom, of a people fighting for their freedom based on the idea of nonviolence. And then Sarojini Naidu continues, standing in the immemorial house, that is our country, the immemorial house, our home, with its roof of snow and its walls of sea, its roof of snow and its walls of sea. As I'm speaking to you from Trivandrum, about 60 miles from Kanyakumari, I'm actually sitting in a room where when I raise my eyes, I see the Arabian Sea. I see the walls of sea that she refers to. So standing in the immemorial house with its roof of snow and walls of sea, once again in the history of humanity, India will rekindle her lamp of wisdom. India will rekindle her lamp of wisdom and inspiration to illuminate the world on its onward march to freedom. So will she be justified of her children, and the children be justified of her. Very powerful idea that India will be a torchbearer of liberty, of love, and of peace, and India will rekindle our own lamp of wisdom and inspiration and illuminate the world march to freedom. And that will be the justification of us, of our people, country, that we deserve this great country of ours, also to a country that country deserves a great people who live in this land. Jawaharlal Nehru said 2 days later on 13th December 1946, moving the Constituent Assembly Objectives Resolution, that the Constitution would give shape in the printed and written word to a nation's dream and aspiration. But only seen is a description of the dream and aspiration of the new nation, the new republic, as eloquent as Sarojini Naidu's description that I read out to you. Recently, on February 10th of this year, 2020, in a case Prithviraj Chauhan versus Union of India and others, the Supreme Court of India, speaking through Justice Ravindra Bhatt in a concurring judgment, said, and I quote, "The Constitution of India is described variously as a charter of governance of the Republic, as a delineation of the powers of the state in its various manifestations with regard to inalienable liberties, and a document delimiting the rights and responsibilities of the Union and its constituent states." This is a kind of administrative understanding of the Constitution, a charter of governance, a delineation of the powers of the state in its various manifestations vis-a-vis inalienable liberties, and a document delimiting the rights and responsibilities of the Union and its constituent states. But Justice Bhatt says, and I quote, he says, "It is more. It is a pact between the people about the relationships that they guarantee to each other, apart from the guarantee of liberties vis-a-vis the state, in what was a society driven along caste and sectarian divisions. And that is why we have the preambular assurance that the Republic would be one which guarantees to its people liberties, dignity, equality of status, and opportunity and fraternity. Very eloquent statement from Justice Butt. He reminds us that our freedom in 1947, defined in our constitution in 1950, adopted 71 years ago today, is not simply about our liberation from foreign rule, from colonial rule, which of course it is, but it is more than that. It is a social contract between the people of India about how they would treat each other. For some people, they wanted equality with the British, vis-a-vis our colonial masters who ruled us, but have wanted equality vis-a-vis other Indian people. What Justice Butt reminds us is that this republic and this constitution is, in the main part, a guarantee about how people will treat each other. And it sets out the values governing the conduct of people towards each other, which is what we mean by liberty, dignity, equality, that we should all treat each other, guaranteeing each other's liberty, respecting each other's dignity, and honoring each other's equality. And above all, in this judgment, which I would encourage all the students to read, Justice Butt talks at length about the much neglected constitutional value of fraternity. Baba Sahib Dr. Ambedkar, the main architect of the Constitution, the person who introduced into the preamble the word fraternity, which was not there before the drafting committee chaired by him took it over, was very modest when he said to the Constituent Assembly on the 4th of November 1948, 1 year, or a little more than a year before the November day on which the Constitution was adopted, on the 4th of November 1948, which was the day that the draft Constitution drafted by the drafting committee was, as settled by the drafting committee, was introduced into the Constituent Assembly. Another important anniversary we honor this month. Dr. Ambedkar said, it is said there is nothing new in the draft Constitution, that about half of it has been copied from the Government of India Act of 1935 and that the rest has been borrowed from constitutions of other countries. Very little of it can claim originality. This is the criticism. One likes to ask, Dr. Ambedkar says, whether there can be anything new in a constitution framed at this hour in the history of the world. More than 100 years have rolled over when the first written constitution was drafted. It has been followed by many countries reducing their constitutions to writing. The scope of a constitution should be has long been settled. Similarly, what the fundamentals of a constitution are also recognized all over the world. Given these facts, all constitutions in their main provisions must look similar. Only new things, if there can be any, in a constitution framed so late in the day, are the variations made to remove the faults and to accommodate it to the needs of the country. The charge of producing a blind copy of the constitutions of other countries is based, I'm sure, of an inadequate study of the constitution. I've shown what's new in the draft constitution, and I'm sure that those who have studied other constitutions and who are prepared to consider the matter dispassionately will agree that the drafting committee, in performing its duty, has not been guilty of such blind and slavish imitation as it is represented to be. In a very polite, but in a very elegant and eloquent manner, Baba Sahib Dr. Ambedkar refutes the argument that this extraordinary document, our constitution, is simply an imitation of other constitutions and other documents. He says it is not. Now, where do we find the unique nature of this constitution? This is a very important question, because I talk now a lot about the constitution to various audiences. to law professors, to law students, to lawyers, to judges, and also to a lot of common people. And what I've understood is, and perhaps that's a main point I want to make in this intervention, is that the common people of our country have not been given an understanding of the soul of the Constitution, what it really stands for, as much as they should have been. And this is important because James Madison, the Ambedkar of America, the main architect of the American Constitution, the fourth president of the United States, once said that all government rests on public opinion. And therefore, we have drafted the Constitution, an extraordinary document, which we'll get into in a little more detail to look at its relationship between democracy and rule of law. We have created a document that is the object of admiration all over the world. I'm a member of a group of people who work on constitutions globally. And all are great admiration of the Indian Constitution and wonder how it has proved to be so resilient and strong. But have we done enough to form a public opinion amongst common non-lawyers in this country? When I say common people, I mean people outside the legal profession, amongst those who are outside the legal profession, about what the Constitution really is. Have we conveyed to them the spirit and soul of the Constitution? I don't think we have. And I think that is a very urgent thing to do. And the main focus of my remaining remarks will be to try to understand the soul and spirit of the Constitution in a way that makes sense to people who are not lawyers. For that, we have to begin with understanding that the Constitution did not come in a vacuum, obviously. It came from the national freedom movement, but it also came from a vast society, a vast landscape, at that time subdivided into states and to British India and a very large number of states. I myself, my home where I'm speaking from now was part of the state of Travancore. And we were not part of British India, although the northern part of my state, Kerala, was part of Madras Presidency, Malabar district. So we were splintered and fragmented into many, many political unities, multiple sovereignties, and multiple tyrannies. In that society, from that society emerged a constitution, and that society and that constitution had to deal with fundamental differences of opinion, political, social, economic, about what kind of society we should be. So, for example, there were differences over whether we should be modern or we should be traditional. Very strong differences which continue even today. Whether we should be secular or whether we should be a religious theocracy, like some of the people of the then India decided, making Pakistan into a theocracy. Should we follow Jinnah and follow the Pakistan model and become a religious theocracy? Should we be a caste society, or is a Varna society the right way in which to organize our society? Should we be democratic or should we be autocratic? And should we have a monarchy? The very leading figures in our country who argued that a monarchy is the right form of government for our country. Now, of course, there is no support for that view. At the time the Constitution was being drafted, there was strong support for that view. Should we be socialist or should we be capitalist? Should we have liberty and freedom, or should we be a society based on obedience and on order, where order is far more important than freedom and liberty, and no freedom can be allowed that will threaten order? Where should we draw the limits of liberty and freedom? Very, very big differences of opinion on that. Is there such a thing as equality at all? There are many people in our legal domain who have argued with me that there is no such thing as equality. This is just a fiction created in Western countries. In fact, we don't even have a real Indian word for equality. We say samanta, that's more like similarity than equality or equity. So they say, what is this equality? We don't understand it, although it's very, very central to the Constitution, and I believe very central to our own ideas in our country, and we'll come to that. Or should we reject equality and have a society based on difference and based on the idea of merit, where the meritorious will rule? And those with less merit, those endowed by God. Chaturvanya maya srishtam guna karma vibhagasha. So people with more guna and based on better karma will rule, and the others will be subordinate to them. Or should we have equality? We have fraternity where everyone is supportive to each other, based on equality, based on mutual love, based on peace, regardless of caste, gender, religion, region. Should we all be sisters and brothers in our country? Or should we reinforce social identity based on religion, based on gender, based on caste, a separate role for women, a separate role for each religion, a separate role for each varna? Cultures kept apart, no intermixing. Should we be a society that gives prime importance to individuals? Or should we have a society where individual is subordinate to the family to the community to the locality, and the locality to the nation? Should we value groups over individuals? At the end of the day, when you have to choose between individual interest and group interest, where will we make that choice? Should we be nationalist, or should we be humanist, looking at humanity as one species, one family? Is there any place for non-violence in our society? Or is violent and legitimate in order to maintain order? Should we look at poverty as a divine decision by God to punish wrong acts in the previous birth? Or should we look at poverty which cannot then be eradicated? Or should we look at poverty as a mere result of an unjust society that can be eradicated through human intervention? Should we be a diverse country? Or should we have homogeneity, a unity based on sameness, samanta? Or should we have a country that celebrates our differences and our diversity? These are 12 fault lines that have existed in this country, in our landscape, for centuries. And these have not lessened even today, let alone at the time the Constitution was drafted. And therefore, in the Constituent Assembly, there were different approaches. I'll just give one or two quotations just to give a flavor. There was no consensus. There were different approaches to these fault lines, these 12 fault lines of Indian society. So Minu Masani, on 17 December 1946, "Sir, it is a fashion of our day to argue that the social and economic changes that are at present required cannot be made unless individual liberty and democracy are first destroyed and an all-powerful state can push its programs through." And the objective resolution of the Constitution and the Constitution itself rejects that thesis. So he talked about these two contending ideas, that individual liberty and democracy are to be destroyed. Democracy is to be destroyed. And an all-powerful state is required to push its programs through forcefully. And that's what India needs. That was a view so important that it was mentioned on 17 December 1946 by no less than Minu Masani, a very distinguished member of the Constituent Assembly, who is not a who was a very respected intellectual as well. On 29 April 1947, Sardar Patel said there were two schools of thought in the committee, and there was a large number of very eminent lawyers who could, this is the Committee on Fundamental Rights, who could scrutinize every word of every sentence. One school considered it advisable to include as many rights as possible in fundamental rights, which could straight away be enforceable in a court of law. Rights in regard to which a citizen may, without difficulty, go straight away to a court of law and get his rights enforced. The other school of thought considered it advisable to restrict fundamental rights to a few essential things that may be considered fundamental. Between the two schools, there was considerable amount of discussion, and finally a mean was drawn, which was considered to be a very good mean. It must not be understood because the report is an interim report that this mean will be changed. It cannot, very essential. There is another report, there may be other points of view. I'm just skipping through. Third school of thought was absent in the committee. That third school would require Sardar Patel that under the fundamental rights which were provided for a free India, there should be no police, there should be no jail, there should be no restrictions on the press, the baton, the lathi, or the bullet. Everybody should be free in a free India to do what he likes. School was absent in the committee. But the two schools of thought that considered this report studied the situation in our country and in countries all over the world and came to a conclusion. That reflects that there were three schools of thought on how to approach the idea of democracy and the idea of rule of law. And one was not even present in the House, according to Sardar Patel, that would take a strong view, a radical view on freedom. Ironically, many people in our country are still migrating to the United States, which probably has the most radical view on freedom of any country in the world. But they do not want it their own country. They consider it dangerous. So, but we reached compromise on rights, not including the more radical view. And in many ways, that's not inappropriate, because ultimately in a large and diverse country, we can only move forward on the basis of some kind of compromise and some kind of middle ground. On 18 July 1947, a member from Orissa, Mr. Lakshmi Narayan Sahu, talked about the fear that the rulers have that too much democracy will sweep the rulers away, will sweep the ruling classes away. And so the Constituent Assembly recognized that there was a very strong sentiment amongst the elites against democracy. Professor K.T. Shah, last but one, 5th November 1948, said, we are talking about democracy almost as a fetish. I know I'm using some unpopular language when I speak in this strain, but please remember that democracy has to be qualitative as much as quantitative. You must remember that what should count ought not to be merely the numbers of hands that are raised or the number of heads present, but the character of those hands and the content of those heads. In the Constitution before us, this qualitative aspect of democracy is very much overlooked. In other words, he was against one person, one vote. Look at the quality of the person and then decide whether he will have a voice in running this country or not, which is a very strongly anti-democratic response. Lastly, a view of one of the most active members of the scheduled tribes in the Constituent Assembly, Mr. Pal Singh from Chota Nagpur. Sir, I speak as a representative of the Aboriginal tribes of Nagpur, he says. I want to say, so far as I've been able to count, we are only 5 of us here, but we are millions and millions, and we are the real owners of India. It has recently become the fashion to talk of quit India. I do hope that this is only a stage for the real rehabilitation and resettlement of the original people of India. Let the British quit. There are then after that all the later comers quit. Then there would be left behind the original people of India. There was a sentiment expressed in the Constituent Assembly that we do not want to be ruled. We do not want to be ruled by people who are coming here and dominating us. And it is not just about throwing out the British, but throwing out all the exploiters of this country. So we see that there was a tremendous variety of views in the Constituent Assembly, because today we are reflecting on the Constituent Assembly and its adoption of this constitution. There was a tremendous diversity of views, and I've given you some somewhat strong views. But the Constitution still, and the Constitution was a compromise. The Constitution interposed itself in these conflicts over these 12 fault lines, it did not stand apart as neutral. There were compromises, but the Constitution is not neutral on the struggles and the controversies going on in the society. So in Indira Sawhney versus Union of India 1992, the Supreme Court said, people in positions of helplessness are the favored children of the Constitution. Constitution is not neutral. In this cauldron of conflict between the powerful and the powerless, no less than the Supreme Court has said that the Constitution favors the people in positions of helplessness. They are the favored children of the Constitution. And that was the great achievement of Baba Sahib, Dr. B.R. Ambedkar, and the small band of people who were in the Constituent Assembly on behalf of the voiceless, powerless people of our country. They fought for freedom. They fought for equality. They fought for dignity because they did not have it. The powerful people had the freedom they wanted, more than the dignity and wealth that they wanted. All the equality that they wanted amongst each other and inequality over the poor people of the country. And therefore, the Constitution includes in it at least 45 provisions, which are what I call revolutionary elements of the Constitution. These include, I'm not going through it, you can find it in the preamble and in part 3 of the Constitution and part 4 of the Constitution, 20 provisions on liberty, 23 provisions on equality, and several provisions on affirmative action and the universal adult franchise, one person, one vote, and more importantly, the right to fraternity. And because the Constitution came up in the struggle, and the Constitution was not neutral, it included in it, yes, it had in it some conservative provisions, which were there as a result of the compromise that Sardar Patel talked about. But included in it, at least, as I said, 45 very important, very powerful provisions with enormous revolutionary potential. And therefore, the first point I want to make is that the Constitution is actually a site of revolutionary struggle. As Article 38 of the Constitution very powerfully says, to secure and protect as effectively as it may a social order in which justice, social, economic, and political shall inform all institutions of national life. Absolutely revolutionary idea. These 45 elements include the liberty of thought, expression, and freedom of thought, expression, belief, faith, worship, speech, assembly, association, movement, residence, no retrospective criminal liability, right against double jeopardy, right against self-incrimination, right to life and personal liberty, right to education, right against arrest and detention, right to defense counsel, right against exploitation, right to conscience, right to religion, right of minorities to preserve and conserve distinct language, script, and culture, and establish and administer their own educational institutions, equality of status, of opportunity, equality before the law, equal protection of the law, prohibition of discrimination on 5 grounds, no disability in access to 4 public places, no discrimination in use of 5 public resources, abolition of untouchability, equal opportunity for public employment, special provisions including affirmative action, reservations for socially and educationally backward classes, scheduled caste, scheduled tribes, abolition of titles, absolutely revolutionary, unthinkable provisions of law in the society from which it emerged, and the fact that they have become far more deeply integrated into our society is a great achievement of the people's movements on our country. And above all, the right to fraternity, which, as I said, in the Prithviraj Chauhan case, Justice Ravindra Bhatt talks about, I would invite you for lack of time to read it. So it is in this context of this struggle of the Constitution as a site for a site for social revolution. The Constitution is a site for social revolution, a site for revolutionary struggle between conservative forces and revolutionary forces. It is in this context we must understand the meaning of the word democracy, which is not mentioned in the Constituent, in the Objectives Resolution of the Constituent Assembly, and is mentioned only 3 times in the Constitution, once in the Preamble and twice recently in the amendment that was introduced on cooperatives. And the rule of law, which was discussed in the Constituent Assembly, but is not mentioned in the Constitution yet, both of these concepts are central to the Constitution. Now, I'll just give you a couple of quotations from the Constituent Assembly about the relationship between what democracy means and the relationship between democracy and rule of law. Mr. Naziruddin Ahmed said on 20 July 1947, democracy means rule of law. That's a very profound definition. We find all kinds of definitions of rule of law, but Mr. Naziruddin Ahmed and others fused in the Constituent Assembly the concepts of democracy and the rule of law. We can talk about it more if we have time. Mr. K.T. Shah also spoke about the rule of law at some length. Mr. Z.H. Larry said, it is necessary to promote parliamentary opposition, which along with the rule of law and a strong press constitutes the bulwark of democracy. So he saw the vital relationship between rule of law and a free press and democracy. And Mr. Naziruddin Ahmed said again, we are erecting one of the finest democracies in the world, but the implication of democracy must be squarely faced. The implication of democracy must be squarely faced. Democracy means a rule of law as opposed to a rule of force. The safety of the state lies in the people's faith in the rule of law. So this is an idea which has been very little explored outside this country, because rule of law is normally juxtaposed against rule of individuals, rule of persons. But here in the Constituent Assembly in our country, on 10 December 1948, 13 June 1949, Mr. Naziruddin Ahmed juxtaposes rule of law against rule of force, and therefore rules out rule of force as unconstitutional. 17 September 1949, Mr. Munshi, K.M. Munshi says, the Privy Council has been a very great unifying force. And for us Indians, it has become the embodiment of the rule of law, a concept on which alone we have based the democratic institutions set up in our constitution. So we see that democracy and rule of law are seen by the Constituent Assembly, however academics in other countries may see it. In the Constituent Assembly, in the context of our constitution, democracy and rule of law are fused into one idea, which we can understand from the simple etymological meaning of the word democracy. And that etymological meaning of the word democracy comes from 2 words, demos and kratos. K-R-A-T-O-S, kratos. Kratos means power. Demos, D-E-M-O-S, means common people, ordinary people, common people, the masses. So democracy means kratos, that is power, is held by common people. Kratos is held by demos, common people. So the concept of democracy is that power is vested in common people. The daily exercise of power is directly or indirectly controlled by common people. And this proximity of power to people is at the heart of democracy. And the rule of law is, as against the rule of force, the rule of elites, is an essential and integral part of democracy. Without rule of law, there cannot be democracy, and without democracy, there cannot be rule of law. May I ask Mr. Valiat how much more time I have so that I can plan my ending?
Sir, you can have enough time, no issue. Time is not a constraint.
Yeah. I will take another five minutes and then I will.
Yeah, yes, no problem. No problem.
So a very good description of a very good description of the controversies about democracy in our country and in our polity in the context of the Constitution is found in the remarks on 13th December 1946, the 5th day of the life of the Constituent Assembly, in the remarks of Jawaharlal Nehru when he was introducing the objectives resolution of the Constituent Assembly. So he says, I've been asked, why have you not put in the word democratic in the objectives resolution? Well, I told them it is conceivable, of course, that a republic may not be democratic, but the whole of our past is witness to the fact that we stand for democratic institutions. Obviously, we are aiming at democracy and nothing less than a democracy. What form of democracy, what shape it might take is another matter. This is present day, many of them in Europe and elsewhere have played a great part in the world's progress. Yet it may be doubtful if those democracies may not have to change their shape somewhat before long if they have to remain completely democratic. And then he goes on to say that the House will notice that in this resolution, although we have not used the word democratic because we thought it is obvious that the word republic contains that word. Republic comes from two words, res, like res judicata, res, the thing. Public means a public. Republic means the rest, the thing, the state, the government is owned by the public. That's what republic means, not by a king, not by God, not by priests, not by an oligarchic elite, but by the public. And so when you say republic, obviously it has a similar meaning to democratic, because democracy, because in a democracy, Kratos is held by demos. In a republic, the rest is held by the public. So they're very similar, they're synonymous words. And so Nehru says that the word republic contains democracy, and we did not want to use unnecessary words and redundant words. But we have done something much more than use the word. We have given the content of democracy in this objectives resolution. And not only the content of democracy, but the content, if I may say so, of economic democracy. And then I'll just give you three paragraphs of three clauses of the objectives resolution, which are fully reflected in the preamble and in part 3 and part 4 of our Constitution. Very important clauses in the objectives resolution of the Constituent Assembly, which is the blueprint of the Constitution. Paragraph 4 says, all power and authority of sovereign independent India, its constituent parts and organs of government are derived from the people. All power in India is derived from the people. Very important principle. That's democracy, demos and kratos, wherein shall be guaranteed and secured to all the people of India, justice, social, economic and political, equality of status of opportunity and before the law, freedom of thought, expression, belief, faith, worship, vocation, association and action subject to law and public morality, and wherein and adequate safeguards for minorities, backward and tribal areas, and depressed and other backward classes. This is a promise made to the people of this country by the Constituent Assembly, in the Constituent Assembly Objectives Resolution and in the Constitution. Therefore, we can say that if democracy is nothing more than, as Nehru says, that all power is derived from the people, that that people have freedom, they have equality, that they have safeguards for minorities and backward and tribal areas and depressed and other backward classes. Any attack on freedom, equality, and special provisions, or any attack on reducing the role of people in the exercise of power is an attack on democracy and is an attack on the rule of law. So what we're witnessing now, a lot of doubt about freedom, a lot of doubt about equality is really a doubt about democracy. The way to take apart democracy is to keep the formal part of democracy, which is simply, for example, elections, keep elections, but take apart freedom, take apart equality, take apart safeguards for minorities, safeguards for backward and tribal areas, safeguards for depressed and other backward classes. And then you have taken apart democracy. Democracy is a comprehensive idea of power being in the hands of people, not only in the public space, but also in the private space. Democracy is a culture, it's a way of life, it's a philosophy. And equality and freedom are elements of that democracy. So you could, as our elections, which are very important part of democracy, but one part of democracy, you can't keep elections and take away freedom and equality. Equally, you cannot take away elections, but keep freedom and equality. They all work together. This is the clear message when you read the Constituent Assembly. Mr. Dhulekar said on 21st January 1947, despotism and democracy are at variance. The two cannot go together. I believe that no longer will any ruler venture to suppress the fundamental rights of his people. Very important language. That was their expectation, that no ruler will ever venture to suppress the fundamental rights of the people, because that is an attack on democracy. Neither the people of the states will allow, neither will the people allow such irresponsible government to function, nor can this assembly render any assistance in this regard. This is in the context of the state, the integration of states into India. Dr. P.K. Sen of Bihar, from Bihar, said on 23rd July 1947, there is a dread of what is called one-man rule, and it is dread that account for the strong opposition to the amendment that was under discussion. Not even for 24 hours, it is said, can we tolerate one-man rule. It is against the fundamental principles of democracy. Now, Nehru recognized that we cannot compromise with democracy. And democracy does not exist without freedom and equality and dignity and protection and safeguards for minorities and backward classes. In recognizing that there are different approaches to democracy, there were doubts expressed in the Constituent Assembly whether the party system would not deteriorate into a government of the wicked and the sly. Dr. P.K. Sen said, as I said earlier, said, it seems as if there is no gentle soul in a party. A few sly persons from a party establish their own government in the name of democracy. So he's saying we should consider other options like decentralization through Panchayati Raj, so that we are protected from the party system, which he said could be fatal to democracy. So we must keep an open mind, that we must, as Nehru said, we must be flexible about the systems of democracy in order to strengthen the fundamental idea that democracy means that power is in the hands of people. That democracy means that there is equality, uncompromising commitment to equality. There is no reasonable restriction on equality under the Constitution. There is no reasonable restriction on dignity under the Constitution. And also liberty with only one restriction, that is, it should not be used to create violence, and it should not be used to take away the liberty of others. So Dr. Ambedkar also said in the Constituent Assembly, I do not say that the principle of parliamentary democracy is the only ideal form of democracy, but he said it is a very important framework for democracy. We have to improve it. Personally, I'm in favor of parliamentary democracy. I think what we need to do is to build public opinion. A multi-party parliamentary democracy must be strengthened because we have experience with it. It has deep roots in our country. We should not abandon it, but we need to reform it, and we the people need to reform it and correct its ailments so that it actually becomes a force for democracy rather than against it. I want to say one concluding point, but before that, I want to quote the most substantive intervention made on the rule of law in the Constituent Assembly, which was by Dr. P. Subbarayan, who was the father of Mohan Kumara Mangalam, a very distinguished, also a very distinguished leader of our country. Dr. Subbarayan said, if there is anything which I would like to cling to in the future of this country, it is rule of law. Professor Dicey, in his Law of the Constitution, has explained this position fully, and we have provided in the Constitution, in the powers vested in the Supreme Court and the High Courts of this country, for any citizen to have his right established as against the government of the day. So rule of law, Dr. Subbarayan said, was lay in citizen being able to establish citizens' rights against the government through the Supreme Court and the High Court, not for the Supreme Court and the High Court to establish the rights of the government against the citizen. That's not the rule of law, according to the Indian Constituent Assembly understanding or discussion of this issue. So that there is no question of encroachment of the rights of the people by the government. And the judiciary has been left independent enough to fulfill this task. There is no judiciary should not place itself as an imperium in imperio. And I feel satisfied that the provisions that have been made in the Constitution will not make the judiciary an imperium in imperio. Of course, there is always that danger. When people talk of separation of power, the separation of power may be made in such a way that the judiciary may be invested with immense power, that it might eventually lead to the breakdown of the government of the day, which I think is not the case in our Constitution. So they saw the risk that an excessively powerful judiciary could be a threat to the Constitution, a threat to the democracy, because that was not the intention of the Constitution. The intention of the Constitution was to have primacy of the people, explicitly, primacy of the power of the people, and the equality and freedom being central to the rights of the people. Lastly, I want to conclude with this, which I want to leave with you. I want to leave just three thoughts with you. The first thought, which I mentioned, is that it is our duty as citizens to build up public opinion and public understanding about the Constitution that they can understand and they can relate to. When I say they, I mean non-lawyers. The second point I made to you is that the Constitution was created and exists in the midst of a huge struggle for social change and social revolution that is going on in this country. And that the Constitution is not a neutral party in the struggle. As the Supreme Court has said, speaking through Justice Kochutoman in the Indira Sawhney judgment, the Supreme Court has said that the powerless are the favored children of the Constitution. So the Constitution has introduced very powerful revolutionary elements that can help the powerless establish a democracy in this country. And I explained to you what the democracy is, that it is in our Constituent Assembly's understanding that democracy is integrally part of freedom and liberty and dignity and fraternity. Also, the rule of law. And the rule of law was seen as a principle that stands against the rule of force. And as Dr. Subbarayan said, the rule of law is seen as an idea that would protect the rights of common people against the encroachment by the government. In conclusion, I want to come back to where I began. How do we explain the Constitution to those who are not lawyers? And as I said, I've been doing this for a long time now. And I explained my understanding of the Constitution as a human being to people. And I find that I believe in that sincerely. And I find that a lot of people are able to then relate to the Constitution using that idea. I understand this book, the Constitution of India, as a book of compassion, Why do I say that? Because if you look at all these various quotations I've given you, ultimately what we are arguing for is a society that is based on Antyodaya and Sarvodaya, Antim ka Udaya, for the last and the least. Sarvodaya, the welfare of all. When we say welfare of all, we mean the welfare of the poorest. Our Constitution is the Constitution of the last and the least, that tries to provide them tools and instruments through which they can regain their equality and their freedom and their dignity. And therefore, if it is based on the last and the least, what is the idea of that is part of the soil of this country, that permeates every religion and every philosophy and every region of this country, that is unique to this country? And I would say it is the idea of compassion. If there is one idea for which India is known throughout the world, from the days of the Buddha and Mahavira right down to today, in the freedom struggle based on ahimsa, it is the idea of compassion, of anukampa, of karuna. it is not surprising that the most beloved judge, the most beloved legal figure in our country is Justice V.R. Krishna Iyer. Just now in Kerala today, I've already had 2 events. For 2 weeks, the probation officers of Kerala are celebrating the 2 weeks between Justice Krishna Iyer's birthday and the day he passed away. There's a 2-week period in his honor as a week to explore how to improve the use of probation to help convicts who are in jail. Why? Because common people of this country understand that Justice Krishna Iyer's jurisprudence has been called by scholars, by himself and by others as Karuna jurisprudence. That what he sees as justice is compassion, anukampa, karuna. Without karuna, without anukampa, there can be no justice. There can be no freedom. There can be no equality. That would be a mechanical, a cruel approach to these values, which will not sit well with the common people of this country. And therefore, I see democracy and I see the rule of law in our country as an expression of compassion. Fraternity that Justice Butt talked about is nothing more than an expression of compassion. Anukampa and compassion are very interesting words. Kampna, means trembling. Anukampa means you tremble when you see the pain of others. It is empathy. Sympathy is having pain and somebody else has pain and you have pain together. It is like tabla playing and sitar playing. They play together. That's symphony. But empathy is different. Anukampa is different. Compassion is different. It is when you feel the pain of the other and you tremble because the other person is in pain. That is the idea behind Buddhism, Jainism, many strands of Hinduism, Islam, and Christianity. Central to all, and Sikhism, and tribal religions are the origin, the fount from which compassion has come. Therefore, I argue that justice is in India. Justice has to include the element of compassion, and the idea of democracy is an expression of compassion. The idea of fraternity is an expression of compassion. So when we express to people that the Constitution of India is a book of compassion, and no action of the Indian state, no action of any part of the Indian state should be devoid of compassion. Whatever that action may be, it should be executed with compassion for everyone, including wrongdoers. And that's what we've been discussing in this probation week. In the name of Justice Krishna Iyer, there's still a couple of events left on that. So let us try to build a public understanding of our Constitution as an expression of the people's belief in compassion, from which non-violence, ahimsa also comes. Dr. Ambedkar has said that non-violence and compassion are very, very central ideas. In fact, he converted to Buddhism, where these are very, very central ideas. So we should convey to people that that this Constitution is an expression of the beliefs of all the people of this country in compassion, that we must develop, we must govern, we must administer, we must take difficult decisions, we must maintain security and protect people. All that is correct, from crime and violence in a very complex word. But let us do so guided by the core idea of this Constitution, which is the idea of compassion. And that will help us to build a public opinion that will deepen the defense of this Constitution of democracy and rule of law. And in turn, strong democracy and strong rule of law based on compassion will strengthen the Constitution, and a strong Constitution in turn will also mutually respect democracy and rule of law. Mr. Varyat, let me stop here. I've spoken for longer than you wanted me to. I apologize, but the topic was quite extensive. Thank you.
Thank you very much, sir, for enlightening all of us on the role which Indian Constitution plays in strengthening our democracy and rule of law. Thank you for your thought-provoking and inspiring words on it. These were indeed real words of wisdom. Professor Dr. Dilip Uke, the Vice Chancellor of Maharashtra National Law University, Mumbai, is a renowned academician in law, and he has varied experience in teaching and research. He is an erudite expert in jurisprudence, constitutional law, and human rights, and his work has in this field is recognized in national and international fora. Sir's excellency in this subject is also recognized by Honorable Justice Krishna Iyer. Recently, he was awarded the Best Academician Award 2019 by Indian National Bar Association. He is a leader with a vision who has made MNLU Mumbai the much cherished university by the law aspirants within a short period of time. He is guiding and leading the university to achieve a newer heights. I would request our Honorable Vice Chancellor to give the presidential address.
Thank you, Gauri. Respected Professor Mohan Gopal sir, our Registrar in charge, Dr. Anil Variyat, all my colleagues, participants, and dear student friends. Very good afternoon to all of you. I wish all of you a happy 71st Constitution Day. Having heard a very eloquent lecture from Professor Mohan Gopal sir, I don't think that I will have to add anything more. It was so eloquent, it was so elaborate. Nevertheless, I would like to mention few points for this at this juncture. I truly agree with what Mohan Gopal sir has said, that Constitution is nothing but the kind of the pact or the social contract. Reason is that the great natural law jurist as well as the international law scholar Hugo Grotius, in his theory of natural law and social contract, rather social contractarian, he has said and observed that constitution of every country has been preceded by the social contract, and people have enacted the constitution of their country depending upon the political, social, economic, and other circumstances existing at that particular point of time. It means that surely the constitution of every country is nothing but the contract, as a product of social contract. And that's what precisely has been reflected in the preamble of the Indian Constitution. As preamble of the Indian Constitution, today we are celebrating Constitution Day. All of us know what is contained in preamble of the Constitution. It is a pact between the people, amongst the people. And that's what preamble of the Indian Constitution says, that we the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political, liberty of thought expression, belief, faith, and worship, equality of status and opportunity, and to promote amongst them all fraternity, assuring the dignity of individuals and unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, we do hereby enact, adopt, and give this Constitution to ourselves. That is what, rather, the pact which has been made. Herein, I would like to say this, that usually we do emphasize upon justice, liberty, and equality. But before referring to justice, liberty, and equality, the notion of democracy, because today's topic on which Professor Mohan Gopal sir spoke, that is democracy and rule of law. The Constituent Assembly, and particularly the drafting committee, pondered upon the notion of democracy. The chairman of drafting committee, the reference which has been made quite a number of times by Gopal sir, Dr. B.R. Ambedkar, he did not accept the definition of democracy given by Abraham Lincoln, that is government of the people, for the people, by the people. He said that is not the true or correct definition of democracy. Rather, he came out, Dr. Ambedkar came out with a different definition of democracy, wherein he had observed that democracy is nothing but the form and method of the government whereby revolutionary changes in the lives of, in the social and economic life of people would be brought without any bloodshed. I repeat what I have said. Dr. Ambedkar came out with the different definition of democracy. That is, democracy is nothing but the form and method of the government whereby revolutionary changes in social and economic life of individuals, of people would be brought without any bloodshed. That is what the definition of democracy which had come out. However, having pointed out this definition of democracy, he said that further, that when we talk about democracy, that is one vote, one value, equality, it is the political democracy. Is that democracy, is that version of democracy would be possible or feasible, suitable to the circumstances of the nation, of the country? His answer was no. And that's why he said, along with this democracy, he talked about the social democracy. Professor Gopal sir made a reference about economic democracy, wherein the social democracy, according to him, social democracy is the democracy which recognizes right to life, liberty, and fraternity as one unit, unison. And that's what rather the social democracy is, the democracy which recognizes life, liberty, and fraternity and equality of the people as the trinity of one value, trinity of one thing, unity of one thing as such. And that's what rather, it is not only the political democracy, but rather it is a social democracy which also contains even the economic democracy. Having said about this, let us come back to the further things. As I said initially, that usually we do emphasize upon the justice, liberty, and equality. However, we tend to ignore either or forget the notion of fraternity, which has been ingrained under the preamble of the Constitution. Fraternity is nothing but the common brotherhood, a sisterhood. I would say it is nothing but humanhood, because it is the notion of fraternity, and along with the fraternity, assuring the dignity of individuals and unity and integrity of the nation. Rather, there was a difference of opinion in the Constituent Assembly as well as particularly in the drafting committee as well, that few members have objected that after fraternity, it should not be the assuring dignity of the individual, the word shall appear, but instead of that, first unity and integrity of the nation shall appear first, and then assuring the dignity of individual shall come afterward. However, Sir Pattabi Sitaramaiah and Dr. Ambedkar, B.R. Ambedkar, resisted to this, and both of them had said that when we talk about unity and integrity of the nation, is it not that unless we assure the dignity of individuals, unless we guarantee the dignity of individuals, till then unity and integrity of the nation would not be possible? Hence, the assuring the dignity of individual is the precondition, is the prerequisite to have the unity and integrity of the nation. And therefore, the notion of fraternity assumes much significance. Dr. Gopal sir had said that where is the soul, where is the core of the Constitution? To my mind, I may not be correct completely, to my mind, the soul is the notion of fraternity which has been ingrained in the preamble. The soul is assuring the dignity of individuals as incorporated in the preamble. Dear friends, it is not the preamble alone which talks about the notion of fraternity. It is the concept, maybe the principle. However, if we look at the material provisions of the Constitution, positive provisions of the Constitution, the express provisions of the Constitution, the notion of fraternity has been expressly provided under Part 4A. Part 4A is nothing but in the form of fundamental duties, which was incorporated by 42nd Constitutional Amendment Act in the year 1976. If you look at Article 51A in the form of fundamental duties, and particularly E, 51AE, small e, which says that to promote, it is the duty, all those are the duties of the citizens, every citizen of India. He says that to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities. That's what Radha. It is not only the principle, it is the duty casted upon us. It is the duty of every citizen of the country. If we read 51A and E together, A is to abide by the Constitution and respect the ideals and institutions, of course, along with national flag, national anthem. To abide by the Constitution and respect the ideals and institutions. What is the ideal? Ideal is the notion of fraternity. Ideal is assuring the dignity of individuals. Ideal is the common brotherhood, which has been incorporated in clause E of 51A, which is the bounden duty. It is not only the duty, it is the dharma of every individual, and that too irrespective of what, transcending religious, linguistic, regional, or sectional diversities. The biggest question is that do we discharge our duty casted upon us by the Constitution, which is also fundamental. We are obsessed with, we crave for our rights as fundamental. These are my fundamental rights. What about those duties which are also equally fundamental? And that's why when you celebrate this day as a Constitution Day, we need to ponder upon, we need to introspect, including myself, and enlighten our conscience that do we discharge our constitutional duty, do we discharge our constitutional dharma, or only we crave for our rights which are fundamental and we ignore, neglect, forget even our duties which are also equally fundamental. And that's why, that is the soul. Fraternity, the notion of fraternity ingrained in the preamble, which has been reflected in the form of integral provision under 51AE along with A of the Constitution of the Indian Constitution. When we talk about democracy and rule of law, both, democracy, as we have pointed out, I do not have to speak much because already the time is there, much time has been taken. However, the notion of rule of law, to which the reference was made by Professor Gopal sir, of Dicey is the notion of rule of law. However, Professor Joseph Raz, in the year 1991 or 92, either of these 2 years, who wrote a research paper published in Modern Law Review, wherein he came out with different versions of the notion of rule of law. Not only those 3 principles which were talked about by Dicey, that equality as per the law administration and the adjudication process has to be in accordance with the judicial process, not like a tribunals. These were the 3 principles pointed out by A.V. Dicey. However, Professor Joseph Raz, in his paper on rule of law published in the Modern Law Review 91-92, he came out with 8 to 9 principles of rule of law, including one of them inter alia, which is most important. One is access to justice. There are several ones, no doubt. And access to justice, that's what rather. If you refer to A.D.M. Jabalpur versus Shivkant Shukla, infamous habeas corpus case, all of us are aware well about it. And particularly the dissenting judgment delivered by Justice Khanna, which became not only subsequently the law of the land, but even it became the 44th Constitutional Amendment Act, because Article 20 and 21 have been excluded from the purview of the power of the President vested in him under Article 359 to suspend the fundamental rights during the period of emergency. That is what rather the value, force of the dissenting judgment of Justice Khanna in A.D.M. Jabalpur. Whole 44th Constitutional Amendment Act was based upon Justice Khanna's dissent. And that's what rather he talk about access to justice as a natural one. You may reject the petition, you may dismiss the petition, but to say that since the national emergency is imposed, the fundamental rights are suspended, including the Article 32, to come to the court, to approach to the court for the enforcement of fundamental rights. The caricature of notion of rule of law carried out by then Chief Justice Beg, that it is not like the Alauddin Chirag, a lamb. You just rub and jinn would appear and would demand, would ask, what do you want, Mere Aka? That is not the notion of rule of law of Chief Justice Beg had said, with great respect, with due respect. That was the perverted caricature of notion of rule of law. Rather, Chief Justice Beg went on to say that during the period of emergency, MISA, then Maintenance of Internal Security Act, martial law, is itself the instance of rule of law. Justice P.N. Bhagwati, and then Chief Justice Beg, Justice Y.V. Chandrachud, the majority, with again great respect, due respect to them. Of course, we know that 44th Council Amendment Act has changed, Muthuswamy has altered, Justice D.Y. Chandrachud overruled virtually. Of course, thereafter, the notion of rule of law, wherein the access to justice has played and playing a very vital role, very pivotal role. It is not only the law as per governance as per the law, administration as per the law, but first and foremost, that law has to be just, reasonable, and fair. That's what rather the substantive due process. As well as the procedure has to be just, reasonable, and fair. And then even thereafter, even access to justice. So notion of rule of law, along with the democracy, not only democracy and rule of law, to my mind, constitutional morality, constitutionalism, and further transformative constitutionalism, along with democracy and rule of law, they are the sustaining principle, strengthening principle of the nation as a civilized one. As we are now living and entering into the different age, different stage, wherein the society is riddled with, the nation is riddled with various diversities, various sections, and moreover, the kind of sectorial things, inequalities, injustices, violences against women. We look at the fundamental duties in itself, denounce the practices which are derogatory to the dignity of women. Would that be a democracy? Would that be a rule of law? Would that be a constitution? And that's why, along with democracy, rule of law, constitutional morality, and constitutionalism, these are the four pillars of the governance of the nation. Along with this, as I said, rightly or wrongly, but it is my perception that the notion of fraternity, notion of common brotherhood, which has been rather made as a fundamental duty, we must read, as Professor Mohan Gopal sir has said, that to me, as I quote him, to me, this is the compassion. Constitution is the compassion. Constitution is the Bible, is the Quran, is the Gita, is the Guru Granth of every Indian citizen. Has to be. We shall enlighten our own conscience, public morality. Then only the nation would progress. Then only society would progress. And that's why, along with the democracy, along with rule of law, constitutional morality also assumes so much significance, so much importance. And along with constitutional morality, constitutionalism, and now as we call it as a transformative constitutionalism. Nevertheless, what is the core? What is the soul? What is the soul? What is the basic foundation? It remains at the bottom, that is fraternity, that is common brotherhood. I urge everybody, including myself, even I need to introspect. I am not an exception. That's what I said. We need to enlighten our conscience and shall adhere, because as duty is casted upon us in clause A 51AA to abide by the constitution and respect the ideals. Do we respect the ideals? Do we abide the constitution? We, in the sense, all, including the government, and we the people of India. We the people of India, cutting across race, religion, region, caste, creed, gender, so on and so forth. When we are going to be human being, when I say this, I mean it. Because I do say, I've been saying this every time. The way and the manner in which we act, we conduct ourselves, that is not befitting to the status of human being. Rather, we tend to behave sometimes worse than animals. If at all any fundamental duty, not by the constitution casted upon, the self-imposed fundamental duty is, that's what I said, the dharma, human dharma, manav dharma, a compassion, a karuna for everybody, for everyone, without asking the name, because the moment we come to know about the name, then we try to find out what would be his caste, what would be his religion, so on and so forth. When we are going to treat human being as a human being, that will be the day of celebration of Constitution Day, in a realistic manner, in a pragmatic manner, in a practical manner. And I hope that that day shall come at earliest as far as possible. With this, I thank all of you, and particularly Professor Mohan Gopal sir, for giving us a time from his schedule and enlightened us with his eloquent, elaborate, and experienced, thought-provoking lecture. Thank you so much.
Thank you, sir, for your enlightening speech on our constitution. Your words always inspire and guide us. So Professor Dr. Anand is serving as in charge registrar and controller of examination of the university. He is also the director and chair professor of 2 research centers in MNLU Mumbai. His dynamic vision, coupled with excellent administrative and academic skills, is enabling the university to make newer strides in the field of legal education. I would request respected registrar sir to give the concluding remarks.
Thank you very much. Respected Chief Guest, Dr. Mohan Gopal sir, respected Vice Chancellor, Dr. Dilip Uke sir. After hearing both the eminent speakers, when I am asked to give a concluding remark, my position, I feel like that of Arjun in the Kurukshetra, at the beginning of the Kurukshetra war. How can I conclude, or how can I give concluding remarks on the words spoken by these two persons? But I will share something which I wanted to say. The making of the Indian Constitution, it is the largest democratic exercise the world has ever seen. Getting democratic or becoming democratic means many things. In the simplest form, we can say it is a rule by the people. If it is ruled by the people, the power must be vested with the people, and the people must realize that they are the masters of them. If they have to realize that they are their own masters, they should have equality, they should have freedom, they should have democracy. It should be there in the system, not as mere words, but it must be real ideals of the governance. And that is why our chief guest has spoken about the need for creating public understanding about the Constitution. Unless the people are not aware about the Constitution, their rights and their duties, the fruits of democracy cannot be brought down to the masses. That is what he meant about creating something about social justice, for which the constitution is an active participant. That we have seen through the decisions of Apex Court and many other courts. At the same time, we should not forget that it is the duty of every one of us to safeguard the democracy. Ever since the independence, there had been attempts to destabilize and weaken the democratic framework from the part of individuals, institutions, and groups, which fortunately we could withstand. I must recollect in the later years of his life, Mahatma Gandhi himself spoke about a system where there is a less concentration and minimum and elimination of inequality, because he found that even in democracy there are dangerous trends of centralization and inequality which is to be arrested by the democratically spirited people like us. Because of hatred and intolerance, today we find a lot of violence among ourselves, which I fear it would weaken the democratic institutions. If the democratic institutions are weakened, there would be no relevance for rule of law. Therefore, my humble wish is that this 1 year of celebration of Constitution's inception, enactment of the Constitution, shall do something towards this direction. With these humble thoughts, I would like to express my thanks to our chief guest, Dr. Mohan Gopal sir, as well as to our vice chancellor, and for the participants. A formal vote of thanks will be proposed by Manisha. Thank you. Thank you very much, sir.
Thank you, sir. We are almost at the end of today's program. Now I would request Manisha Katyal, who is the final year student of Maharashtra National Law University, Mumbai, to propose the vote of thanks. Over to you, Manisha.
Thank you, ma'am. Good afternoon, respected Dr. G. Mohan Gopal sir, Honorable Vice Chancellor, respected Registrar sir, Dr. Kiran Rai, Sajid sir, Gauri ma'am, and my dear friends. I, Manisha Katyal, would like to thank you for taking time out of your schedule and attending the concluding event of the 1-year-long program. It was on 26th November 2019 when we decided to celebrate the 70th anniversary of Constitution Day. It was decided to celebrate it for the whole year. There were several programs conducted to celebrate the anniversary for the year, which included outreach activity in the IES Modern English School, in which the young minds of India were taught about the rights they have and the duties they should take care of. Faculty roundtable on emerging issues and challenges in the constitutional law. Policy for Young Leaders, organized in association with Center for Civil Society. Special lectures by Professor Reena Pillai and Dr. Rita Bansal on women empowerment and Indian Constitution, and affirmative action under Indian Constitution, respectively. Seminar organized in the theme of laws relating to women in association with Family Code Bar, and many more. The Constitution, which is not just an abstract idea and is connected with us in our everyday life and celebrated. Today, I would like to take this opportunity to thank Dr. Mohan Gopal sir for joining with us and giving us the opportunity to hear him. It had been an honor to have you present with us, sir. I would like to thank the organizations and guest lecturers who helped us in organizing this year-long program. I would also like to thank Professor Dr. Dilip Uke and Professor Dr. Anil Variath for taking up this initiative to celebrate the Constitution year and giving us this opportunity, which not only helped us to gain different perspective, but also helped us to work closely with the society and gain immense knowledge. Another big thanks to Ms. Gauri Rane and faculties and administrative staff of Maharashtra National Law University, Mumbai, for giving us constant support and guidance. And finally, I would like to thank all the attendees of the webinar. Your participation ensured the success of this event. With this, we conclude this event. Thank you.
Thank you. Thank you, sir.
Thank you so much, sir.
Thank you, sir.
Thank you, sir.
Yeah. Yes, sir. Thank you. Thank you, sir. Sir, my yeah, fine. Sir.